Thank you, Council. We are being live streamed. This is a meeting of the House Government Operations and Health Facilities Subcommittee. There are 5 bills on our agenda for this morning, and our first act will be to remove House Bill 13 from the agenda. There are discussions underway between the sponsor and the interested parties, and they've made some progress, but I have spoken or emailed the sponsor, Delegate Carr, and he is amenable to our taking this bill off today's hearing list and hopefully resolving the remaining issues and bringing it up at next week's meeting. Is that correct, Delegate Carr? Thank you. Thank you. House Bill 163. Delegate Carr, Public Information Act required denials, sociological information and distribution lists. Council, could you please summarize the bill? We did discuss it last week. Summarize the bill and its history in both the subcommittee and the full committee and the House floor.
This is an emergency bill. It modifies the definition of distribution list as it applies to the denial of inspection of distribution lists under the Public Information Act to exclude a list of recipients of specified notices from the State Highway Administration or Maryland Transit Administration relating to environmental and engineering studies on private property under the state's eminent domain statute. A custodian must allow inspection of such a notice or a list of recipients of such a notice only on receipt of a written application and a statement signed under oath that the notice or list is not intended to be used for commercial solicitation. The bill further specifies that the definition of sociological information adopted under rules or regulations by an official custodian may not include the above specified notices or recipient lists. And the bill requires a custodian to deny inspection of only the part of a distribution list that identifies an individual's physical address, email address, or telephone number rather than the full distribution list. A very similar bill was introduced last year. The difference is that last year's bill was not an emergency bill. It was House Bill 272 of 2021, and that bill passed the House unanimously. This bill was also discussed last week in subcommittee. A question was posed last week about what the violation would be for someone signing the oath that the information was not to be used for commercial purposes and then violating that oath. That would be, if the person was found to have violated that, it is guilty of a misdemeanor of perjury, and on conviction is subject to imprisonment not exceeding 10 years.
Is there discussion on the bill? Is there a motion on the bill?
Move the bill.
Hold on, I'm trying to discuss it. You missed my hand.
I'm sorry. Delegate Saliga.
Thank you so much. So, I expressed some concerns about protecting information of people who don't want their information shared. And Delegate Carr, I appreciate your email where, you laid out the rationale on those 3 instances, to show why you put the bill in. But I would give you an instance in my district. Again, just to remind the subcommittee, this bill is about eminent domain, or it's narrowly focused on properties, and Lindsay, make sure I'm right on this. Property owners, properties that are in a place that the Highway Administration or Department of Transportation may have to use eminent domain. Is that right, Lindsay? It's kind of focused because it says 12-11 of the real property article where it falls. And that again on
it is it's to enter the property to do like surveying work. And it is with the idea that there might be an acquisition or future public use of the property.
Okay, so in my district, I live near 95 where they've expanded the high-speed toll lanes and they've made it up to White Marsh and they're expanding it eventually to Delaware. But the next expansion of the highway goes through my district, and there's a park and ride there that's been under a lot of contention, about moving this park and ride. It's actually crazy. It's between the north and southbound lanes. So it was in a crazy spot to start with. So we've been in, the negotiations and planning for at least 4 years and figuring out where to move the park and ride. So, a decision was made to move it onto the east side, and Department of Transportation contacted the property owners in that area to talk to them about selling their property. The last thing that MDOT wants to do is eminent domain someone's property. They always work towards some kind of favorable negotiations with property owners to have them sell their property. And eminent domain, as it should be, is a last resort type of thing. So the property owners that live there, MDOT, was and probably still is in negotiations with them. They may have concluded that, I don't know. But if I were a property owner on that street, and it's easy to figure out, it's all public information, the hearings, where's this property, where's the park and ride going to go? If I wanted to talk to those property owners, I could go knock on their doors, give them my card and say, hey, if you need me, here's my card. Let me know how I can help. A realtor could do that. A lawyer could do that. There's nothing stopping someone from doing that right now. However, if this bill passes, there's no way of me as the property owner to say, I don't want you to share my information. Like, you've sent me this letter, you've contacted me about surveyors, about possibly acquiring my property, but I don't want you to share that information. I want that to be kept private. So Delegate Carr, what can you do to assure property owners or recipients of these communications that their information will indeed be private if they so desire?
Yeah, thank you, Delegate Shalega,
Hi,
for that
Terry speaking.
question. Would you like me to respond, Mr. Chair?
Yeah, Terry, you're not on mute.
Oh, sorry. Okay.
Delegate Carr.
Yeah, thank you, Mr. Chairman, and thank you, Delegate Shalega, for that question. So I sent around an email just sort of explaining my thought process for this bill, and I'm trying to reset the clock back to the way things used to be. So MDOT used to have a policy of being open. They would share information with the public, with elected officials when it was requested. And they never hesitated to do that for me when I asked for that kind of information in the past. And, there were never, this type of information was always available under the PIA, and there were never any of these issues with concerns or privacy. No constituent ever came to me and said, this is an issue that has to be addressed in legislation. But there was a policy change in MDOT in recent years where they've become very reluctant to share information. And I think they've instructed their attorneys to, use every loophole they can in the MPIA to not share information when they're building their projects. So I'm simply seeking to put it back the way it was, to close down these loopholes that I think are being abused, not in the way that the General Assembly intended. So I'm not concerned about the issue that you raise, because that never happened, in the years and decades under the old policy where information like this is shared. And the type of information, I sent around an example of the notice that my constituent, Ms. Fox, received. And, this is not cybersecurity. This is not, sensitive infrastructure. This is not like super secret or sensitive information. It's just a letter, starting the very, very beginning of, a surveying process. And I just don't think it would be helpful to the bill to amend it in the way that you are envisioning.
Well, I would say just because we used to do something some way is, not an excuse to go back. that people want their privacy. They want their information protected. So Delegate Carr, you're saying you don't have any desire to protect people's private information, to give them an opportunity to opt out of sharing their info, because they can't just they're going to share it with you. They have to share it with everyone.
Yes, Delegate. So the hypothetical you're raising, I do not see that as a problem that needs to be solved or included in this bill. And, I haven't seen any language in terms of an amendment that you would like to propose, but just in the way you're describing it, it doesn't sound like something that is, needed or helpful to the bill, and might actually be the opposite.
Delegate Kaiser.
Thank you, Mr. Chairman. As I listen to Delegate Carr and Delegate Shalega, it seems to be the same discussion as last week on this issue. And while the argument that this is the way we did it before isn't compelling to me, the argument of why we need it is a little bit more compelling to me. I hope we move forward with this bill as it is, but I would suggest to Delegate Shalega or anyone else that certainly if there's a problem moving forward, that's the best thing about us coming back every year. We can fix it. So I think it's we should do this because we need to be able to reach out to people and know and be able to confirm that all the people who deserved a letter got a letter. So that's all I have.
Thank you. Delegate Hill, followed by Delegate Johnson.
Thank you, Mr. Chairman. Delegate Shalega and Delegate Carr. I'm thinking about, our public information disclosures, and we have an opt-in, opt-out that basically says, we want to be notified if someone, peruses our records. Now, this is a much larger body of the public, but I'm wondering if either, when people get the notice that they could say, and if you don't want your information shared, some qualifier, if that would be acceptable, or something like we have, which they would have an option of saying, I want to know if someone asks that my receiving this notification, if someone asks for that information, I want to know that they requested that information. So I'm just throwing that out to both of you.
So I guess I'll start. So my thought is that would sort of unnecessarily complicate the bill and wouldn't help to address the problem I'm trying to solve. But as Delegate Kaiser said, if we go down this road with this bill, then, if that becomes an issue, we can always go back and address it in the future.
And I appreciate that, Delegate Hill. That's, I think, minimally an opportunity for people to opt out. I mean, I would say that the posture should be you're opted out. And if you don't mind your information being shared, because, if you're the property owner that had lawyers and realtors and everybody else knocking on your door, you, or politicians, you might be like, too late for you to go back and fix it. You've already violated the trust. So I think as lawmakers, we can't say, well, let's just throw some mud on the wall. And if it sticks, great. And if not, we'll come back and fix it next time. So, minimally an opt out on the transportation letter, because again, this is narrow. It's eminent domain. It's properties where, MDOT, it's not broad, this is pretty sensitive information. And I think property owners have a right to not have their information shared in these instances if they so desire. So, I would think that minimally opting out, but, potentially taking the position that you're opted out. And if you don't mind your information being shared, go ahead and opt in.
If I may, Delegate Hill, you referred to the provision in law that says that our financial records, our financial disclosure, there is a notice. Do you know, or if you don't, does council know, is that an opt-in or an opt-out? My thinking be the reason for the question, that if we're trying to use this as a model, this existing provision, that we should also go the same route.
We
of
have
opt-in and opt-out.
on our financial disclosure, we have both. It's neither. It's like, I do agree that I want to be notified if someone looks at my records, or I don't agree. I believe, and Lindsay, you can correct me, but I believe we have to choose one or the other. And I think to both delegates' points, this is public information, but what's not public is the link that says my property is being considered for eminent domain. And I think that's what I'm hearing in Delegate Shalega. And I'm hearing very much Delegate Carr's point that, for us to do our jobs, we need to know that. And I think that soft spot is saying to the person, this is a letter you got. There may be, government entities and other folks that want to know who's being affected. Are you okay with having that information shared? And again, we still have the protections of other folks. And I did read, Delegate Carr's response to, MDOT saying that, there's no way to identify the purposes of whoever wants that information, including the press. And I don't know that that's been a huge issue, but I do. So I just think there's something in between here that we might be able to do to address both.
Council, Lindsay?
I was just going to say, I haven't actually seen the specific form that you guys fill out for your financial disclosures, but I would note that there's a little bit of a difference there between your financial disclosures can be accessed by the public, but you're told about it, versus you could opt out from having it disclosed to the public. So there's sort of a distinction there, as you want folks to be notified that the information has been accessed by someone, or do you want them to be able to opt out of having the information accessed?
Yeah, so my suggestion, Delegate Shalega was asking for an opt-in, opt-out. I'm suggesting that at the very least, we could say, I want to be notified. So if I know that such and such realty has found out about this, or such and such lawyer, and when I get notified, when they come to my door, oh, you're the person who accessed my records, right? If I get a call from a newspaper person, I know they went through my financial disclosure. I'm prepared, or at least have an idea, do I want to take that call or not? So I think that does give the public, something to make a decision about. Is this a realtor or a newspaper person or somebody I want to deal with? Because I know they're probably calling because last week they went and they found out that MDOT sent me a letter.
Delegate Kipke.
Thank you, Mr. Chairman. Good morning, everyone. You just sort of playing the devil's advocate. What I'm thinking about this is, when you pass a bill like this, and I certainly voted for it last year, I'm just wondering, are we creating an opportunity for people to sort of be harassed by politicians? Obviously, eminent domain type situations are tough. They're emotional, they're tough. Political candidates and or elected officials can put out their statements about what they believe about whether or not a project is right or wrong. But, the proponent of the bill is advocating that this is a way to make sure that the people receive their letters. So I'm curious, is there any evidence that people did not receive their letters? And then the second follow-up question to the proponent is, isn't this just a way for people with, political beliefs or a political agenda to have a consolidated list to sort of target those individual property owners, for political gain? And as I said, I'm playing the devil's advocate here. I'm just asking the question. I mean, if an eminent domain was coming through my district, which it had prior to me being elected, I can see how different individuals with a political agenda would want access to those lists to make hay with it one way or the other. So, I guess, can you answer the question, Delegate Carr? Is there any evidence that people did not receive these letters that they were supposed to receive as required by law? And is that the intent of the bill? And then as I'm playing devil's advocate on the political side, can you just give some feedback to that?
Sure. So the circumstance that led to the bill was a municipality reached out to me and my district mates saying, my citizens are getting these letters. We're concerned. We're not getting communications from MDOT, but our citizens are getting these letters. And, so the approach we took was to try to find out, okay, what's the footprint of this project? Who are these letters being sent to? So I think the goal in this case was more to identify what's the footprint that they're looking at, and it turned out to be about 3,700 people, but MDOT, pulled out every trick in the book to not share, which properties were involved. So I don't think that was the goal, but, in earlier projects, like there was a Purple Line wetlands mitigation project that was in my district where they were turning a park that was heavily used into a wetland. And in that case, I was concerned about whether the users of the park, had received a notice about this activity and the meeting for which it was discussed. So, I asked, can you let me know who did you notify about this project in the meeting? And it turns out they had only notified the immediately adjacent property owners to the park, not the wider community of people who might use the park. So I think in that case, I was able to identify maybe a shortcoming where they didn't notify as thoroughly or as well as they could. But under the 2020, the current MDOT, they would have just said, sorry, I can't, that's a distribution list. I'm not allowed to give that to you. And I would not have been aware that, of their insufficient notice on this, park, turning a park into a wetland opposite of drain the swamp issue. So I guess that's my response. I guess my belief is in a democratic society, it's valuable for people to know what their government's doing. That's the whole purpose of the Public Information Act. So I err on the side of sharing information. You can't control every possible use. I think the affidavit is a really prudent step to address that concern, and it mirrors language from the election law article. And there's a couple other clauses like that in the PIA for motor vehicle records and for another type of records too. So I'm personally not concerned that there will be an industry created of political influence being sent to recipients of these notices.
Thank you, Mr. Chairman.
Delegate Kaiser.
Thank you, Mr. Chairman. I just keep going back to the part that, not that let's go back to the old model, but remembering that under the old model, all the concerns that have been put out there did not happen. And so I think it's always worth the public policy argument to think through those possibilities, but there's no evidence those things were happening. So I guess I'm hoping we can move forward on the bill. Thank you.
I would just add, in terms of eminent domain, that at the first meeting on the red line, which will go through in part the district that I represent, there were people who had been, I hate to say victim, but that's the word that comes to mind, whose properties had been condemned to build the highway to nowhere. And so therefore they did not want that to happen to them a second time. And so from that perspective, that circumstance, I see this bill as enabling an elected official to assist individuals who have received such a notice, and not for the purpose of political advantage. And I would think that if I had received such a notice as a homeowner, I would welcome some assistance in responding to it, to look after the interests of my property and, more importantly, my family. So those are my thoughts. Is there a motion? Is an amendment before us? Delegate Zaliga, do you wish to offer an amendment?
If I can offer a verbal amendment, or if you'd like something in writing, I can wait until it goes to the committee, or we can vote on it next week. But certainly, I would like an amendment that includes an opportunity for recipients of any such letters to opt out of having their information shared.
Okay, is there any objection
I'll
from the
second it.
committee to voting on this amendment verbally? There is no objection. Okay, so can you please then restate what this amendment would do?
Any such letter sent out with regards to this section, the bill deals with 12-11 of the real property article sent out by MDOT would include an opt-out provision for recipients of the letter to opt out of having their information shared.
They would have to affirmatively opt out.
Yeah, I think, of course, I'd love it the other way, but I'm a realist, so I can do math. So we'll stick with it, with an opt-out, that it gives property owners that opportunity to say, I prefer that you do not share my information.
Okay. Is there discussion? We have had discussion. Anything further?
Well,
Delegate Hill.
yes, I just want to be
Delegate
clear.
Johnson.
Oh, Delegate Johnson, I'm sorry.
Okay, fine. Since you haven't spoken, Delegate Johnson.
Thank you, Mr. Chairman. And the question is for Delegate Szeliga. In that amendment, Delegate, when you say share my information, a lot of that information is already out there for the public access. Are you meaning the information about my eminent domain letter specifically?
Well, the bill is about a distribution list. So it's, on page 2, lines 14, it talks about what a distribution list is, and then it goes on to talk about the custodian shall allow inspection of a notice or list of the recipients of the notice. So we would just say that the recipients would have an option, the people that we're talking about would have an option to say, I accept those whom have opted out of being included in this distribution list that could be shared with anyone who asks.
So I thought our topic was about eminent domain letters. So is that what we're talking about, or other information is pretty broad and a lot of that's already out there. So are we talking about information on the eminent domain letter?
Yeah, so this is specifically, Delegate Carr wants to be able to call MDOT or write them, obviously not call them, and say, I'm requesting under the Public Information Act, the distribution list of, whom you sent this letter to on this date. So it's narrow, Delegate Johnson. It's not, the person saying I'm opting out of everything ever. It's specific to what Delegate Carr is looking for, is the ability to get a list of who the letter was sent to.
Okay, so we are narrowing that amendment to information pertaining to the letter.
Yes. So
Okay.
somebody would say, just don't, send them the list of, you contacted 40 people, I don't want to be, I've decided I don't want to be my information to be shared. So now you can contact 39 people. So the PIA would come back to Delegate Carr and say, here's the list of people who didn't say they opted out of having their information.
About the letter.
Yes, it's just specific to each letter. I mean, Delegate Carr can't do a PIA like, I want to know everybody you ever contacted, because it's specific to an eminent domain issue.
Okay, thank you. Thank you, Mr. Chairman.
Thank you. Delegate Hill.
Yeah, a couple things. So I wanted to clarify that really what the bill does is saying that asking about who received this type of notice is not a distribution list, therefore is an exception to the current law, and MDOT is required to give it. So we're actually not talking about distribution lists, okay?
You're right. Sorry, you are
No, it's
correct.
right. And so, and the other thing is that I don't believe I have an objection to an opt-out, and I appreciate your moving on, not an opt-in. But if it is voted down, I will be making a motion of notification. I would say it's probably cheaper for MDOT with your amendment, right? Because they just have the information and they just have to internally, whereas with my information, if my counter, which is that people have to be notified, that means that every time MDOT is notified or gets a PIA, right? That if I said I want out and I want notification, they've got to keep contacting me to say, oh, your information was looked at. So I'm sure my counter proposal will be more expensive. I think it's better in other ways, but as we're looking at your proposal, since I had raised this alternative, I just want people to know I may have a more expensive alternative, which may make it less desirable. And
Okay.
I was
Thank
just
you,
curious
Delegate
about
Hill.
Delegate Carr's position on both of those options, the opt-out
No,
of my link to this document that being shared versus my saying I want to be notified if this information is shared.
Okay. I'm going to ask for all those in favor. Delegates Lega, one last time, please just state your amendment, the one that is now before us.
Any notification that MDOT sends with regards to eminent domain will include an provision that allows recipients to opt out of having their information shared under a Maryland Public Information Act request.
Okay. All those, I'm going to ask by showing of the electronic or the digital hand. All those in favor of this amendment, please raise your digital hand. See, 1, 2, 3. All right, there are 1, 2, 3, 4, 5, 6. 6 in favor. All those opposed? Thank you. Please lower your hands. All those who oppose the amendment, please raise your digital hand. The amendment passes. Okay. Delegate Hill, your amendment thus is not, you will not be offering it. Okay.
Correct. I will not be offering it. Thank
Okay.
you.
Is there a motion on the bill as amended?
The bill.
So moved
Second.
and seconded.
Second.
Okay, let's, using digital hands again. All those in favor of the bill as amended, please raise your digital hand. I guess that includes me. There are 10 in favor. All those opposed? There's no one. Oh, I haven't done it myself. So,
You're on mute, Chairman.
okay, it is unanimous.
Looks like Delegate Carr better get over there into the Senate and start hustling some votes.
Okay, that bill is moved forward with an amendment. The next bill before the subcommittee, where's my list? House Bill 167, Delegate Bagnall. Council, Lindsay.
This bill was briefly discussed last week. It establishes the commission to establish a Maryland Women Veterans Memorial to provide recommendations for the funding, design, construction, and placement of an appropriate memorial dedicated to Maryland women veterans. The commission must submit a preliminary report by February 1st, 2023, and a final report by September 30th, 2023. There was an amendment that was circulated on this bill. The amendment just alters the membership of the commission. There were several legislative members that are removed because it is an election year. And rather than having the governor appoint several members of the commission, which would also be a problem because he will not be able to appoint members to the commission very soon, the members are instead designated by the Secretary of Veterans Affairs. Includes 4 representatives of veteran service organizations who are women, also designated by the Secretary of Veterans Affairs, and adds 1 representative of the Maryland National Guard.
Are there questions on the bill? Debate on the bill? I assume first, is there a motion on the amendments?
Move the amendments. Second.
Moved and seconded. I think we can do this on a voice vote. All those in favor of the amendments, say aye.
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 All those opposed? Okay, we will now, is there a motion on the bill as amended?
Move the
Motion
bill
to-
as amended.
Second.
Simultaneously moved and seconded. All right, those in favor, please indicate with your digital hand. Those in favor of the bill as amended. Okay. It is unanimous. You should be smiling, Delegate Bagnall. Thank you. Okay. Next bill is House Bill 230. Well, let's jump ahead to 246, which is, I believe, less controversial. So House Bill 246. Council?
This bill increases from 1 to 3 years the length of time a public body must keep a copy of a specified meeting notice or written statement about the closing of a public meeting under the Open Meetings Act. To the extent practicable, a public body must post written statements about the closing of a public meeting online. If a public body does not post a written statement, meeting minutes, or a specified meeting recording online, the public body must provide an electronic copy of the written statement, minutes, or recording to a requester within 2 business days of receiving a request. You have also received via email an amendment from the sponsor on this bill that clarifies that the time period for providing minutes to a requester is within 2 days, or if the minutes have not yet been adopted by the public body at the time of the request, within 2 days after the public body approves the minutes.
Was there any opposition to this bill at the public hearing, Council?
MML opposed the bill.
Opposed 246. Okay. Is there anyone here from MML?
Actually, I think I have them listed as favorable with amendments. They opposed 235.
Yeah, I have them favorable with amendments as well.
Okay. Does this amendment address their concern? Council? Or Council, does this amendment address the concern? The articulated concern of in the testimony? Or is there someone here from MML? Speak now or hold your
There was
peace.
an error in the MML testimony, so I'm just trying to double check to make sure what their concern is.
All right, well, we'll recognize Delegate Zaliga while you're doing that. Delegate Zaliga.
Thank you. In the letter from the State of Maryland Open Meetings Compliance Board, it says 2 business days may be an impracticably short amount of time. What, Delegate Carr, did you have an amendment that was expanding that?
So the amendment is was Mako's suggestion, which is to have the bill apply only to approved minutes as opposed to any sort of minutes. And I support that. So we had that drafted into an amendment. So I had emailed to MML to say, I would be, because minutes are, they're special. Minutes must be immediately available. If someone shows up at your place of business during business hours, you have to allow inspection of minutes immediately. There's no 2 days or 5 days or 30 days, but in a pandemic, people don't always want to get in their car and drive to a public body's place of business, or maybe they're closed because they're on lockdown or something like that. So it's really impractical to do what's already in the act, or to go under the MPIA. Then you're into 30 days. So that's why I proposed 2 days. But I would be amenable to 5 days, to give more time than 2 days. 5 business days, but MML still found that objectionable. I think there doesn't seem to be any, every other part of the bill, everyone agrees with. MML only opposes just this provision of that they have to email the minutes within 2 days. So I offered 5, they didn't go for that.
Well,
Would you still be amenable to 5? Because I think that's reasonable. And when you read the Open Meetings Compliance Board information, they talk about public bodies vary greatly in size and resources. And, look, Delegate Carr, if they posted it online, they wouldn't have to email it. So, that would simplify it. But clearly, if they're a smaller body and they're not posting it online, there's a reason they're not. So I think a week gives them, I think that was a great suggestion by you, and I would ask you to consider amending it to change that 2 to 5 days. That would help some of those smaller bodies be compliant.
So I would support 5 business days, but I know MML still finds that problematic, but the sponsor is fine with it.
okay. Delegate Kaiser.
I have a question. I thought I read the other day or heard during the hearing something that it's after the minutes are approved. And if that's correct, minutes are approved sometimes at the next meeting, 6-8 weeks later, with some groups, or maybe a week or 2, depending. So is that the intent here? And doesn't that then slow down the information?
So with the amendment that was circulated, it clarifies that it's within 2 business days, or if the minutes haven't been approved yet, within 2 business days of when they're approved. So that was Mako's suggestion, which I support. And I guess we're talking about changing 2 business days to 5 business days, which I would also support. Did I answer the question?
Mr. Chair, if I could also ask another.
Certainly.
What about people who want the minutes but aren't online? Is there a way to deal with that?
What, Delegate Kaiser? I didn't hear you. I'm sorry.
For those who don't have computer access, do we have a procedure in place for them?
If I could respond.
Certainly.
So what's not changing in the Open Meetings Act is that a person has the right to show up in person at the public body's place of business. And as long as it's during normal business hours, those minutes are supposed to be available for immediate inspection, or they can request those minutes under the Maryland Public Information Act as well, which could be through a snail mail letter.
Okay. So the amendment before us is to change 2 business days to 5 business days wherever it appears in the new language, the language that this bill would add to the code. Is that correct?
Can I clarify?
Go ahead, please.
The first thing that I wanted to clarify is I did look up MML, as I mentioned, had a mistake in their testimony, their written testimony that they submitted on this bill. What their amendment that they would have suggested is to strike the language, both relating to written statement and minutes, providing it within the 2 days. So they would have just struck that completely from the bill. Secondly, I think that there's sort of two amendments being considered right now. One is the 5 days versus 2 days, which is language in the bill now. And then Delegate Carr's amendment to change
Okay.
the minutes to approved minutes.
Oh, but there's also a 2 business days language there, which would be
There
changed.
is. So that would also need to be changed to 5 days. But I'm just saying there's sort of two distinct elements.
Okay, sure. Thank you. Thank you. Thank you. All right, so the First Amendment is to change 2 business days to 5. All those in favor, please say aye.
A question.
Yes.
Aye.
Is that a question? Question.
Aye.
Is there still a question?
There, I'm okay with the 5, but Lindsay just ran through that, and I'm now trying to find out, other than the 5 and 2, what are we, under this bill, what exactly are we asking public bodies to do in 5 days' time?
So the 5 days time applies both to post, if they don't post a written statement of closing online, then now within 5 days rather than within 2 business days, they would have to email an electronic copy of that written.
So,
And then this same 5 days applies to sharing the well, if we get to the next amendment, approved minutes or the minutes of the public body.
okay, so when we talk about if they don't post, at least as I'm reading this again, it is, I need to be clear that it's clear that this is not, if they choose not to post, we're talking about their regular habits. If their habits are that they post stuff online, right? This is not them saying, we don't want these minutes getting out, so let's not post it. Now we just bought ourselves some more time. I'm not clear this bill makes that distinction between what they routinely do and their ability to sort of skirt the transparency by making an exception for this particular meeting.
So existing law requires, to the extent practicable, a public body to post online the minutes or recordings of their meetings. The bill adds the same language with regard to the written statement. To the extent practicable, a public body shall post online the written statement. And then in both of those places, if they don't post it online because it's not practicable for that public body for whatever reason, then on request, they have to provide an electronic copy of it.
I'm sorry, what you just, because that's what I read, if, that to the extent practicable, and then if they don't. But then you said, because to the extent practical, they can't. And I guess what I'm asking is, do we need to be clear in that too, that if they do not post because they cannot, as opposed to they do not post, they just didn't do it. Because to the extent practicable is how they're supposed to post, but there are a lot of reasons why they might not have posted. So I'm just asking for legal sufficiency when we say if they do not post for whatever reason, or, then they have to have 5 days, or if they do not post because it was impracticable. And if we don't need that, that's fine. I just am asking.
The way the bill's written now, it doesn't specify why they didn't post. It just says if they did not post it, then they have to provide it electronically on request.
All right, that's what I thought. Okay, thank you.
Okay, Delegate Zaliga.
Thanks. Delegate Hill, if you read the Open Meetings Compliance Board letter, they just note they're just information only. They're not favorable or unfavorable. But, I read the testimony and thought it made sense. We note that Maryland's public bodies vary greatly in size, staffing, and resources, and it may be difficult for some bodies to provide requested materials in 2 business days. Moreover, requiring public bodies to produce closing statements and minutes in a short period of time is likely to lead to an increase in complaints to the Compliance Board with no appreciable benefit to the public. So I thought, well, seems, if we give it to 5, obviously we want appreciable benefits to the public. It's the whole reason we have that. And so that's why I thought 5 sounded reasonable as well. And apparently Delegate Carr had offered
No,
that
I'm
up.
good with 5. It wasn't about 5. It was about whether there was something else we needed to do. And I appreciate that because my laptop is with OIS, so I can't pull up the testimony. So thank you.
Okay, the amendment before us is to change 2 days, 2 business days to 5 business days. All those in favor, please say aye.
Aye.
Hi.
All those
Aye.
opposed? It is accepted. The second amendment is the one that is in the bill as it was distributed with regard to if the minutes have not been approved by the public body at the time of the request within 5 business days after the minutes are approved by the public.
Oh. Wow, I already signed it.
Okay, all those in favor of this amendment, say aye.
Hi.
All those opposed? Okay, is there a motion on the bill as amended?
Move the bill
Motion
as
on the bill.
amended.
Second.
Favorable and second. All those in favor, please indicate with your digital hand. Okay, all those opposed? It is unanimous in favor. Okey doke. Last bill would be House Bill 235, Open Meetings Act definition, administrative functions. Council.
Sorry. This bill alters the definition of administrative function as it applies to the Open Meetings Act to exclude the appointment, employment, assignment, promotion, discipline, demotion, compensation, removal, resignation, or performance evaluation of an appointee, employee, or official over whom the public body has direct jurisdiction. Therefore, these matters do not fall under the Open Meetings Act administrative function exclusion. For a public body to discuss these matters outside of an open meeting, the public body must close the meeting in accordance with the existing Open Meetings Act procedures for closed sessions. This bill was introduced last year as House Bill 920. It was voted in HGO 17-7, and then it was recommitted to HGO on the House floor. So the full House did not vote on this bill last year.
Sponsor.
Yeah, thank you, Mr. Chairman. So this is a bill, that we did pass last year. The chairman pulled it back, I think out of respect for the Open Meetings Compliance Board. So the bill is in the same posture. The chair did write a letter to the Open Meetings Compliance Board asking, and Ms. Marshall is here, who is the chair of that body, to look into this issue and report back that the committee is concerned and if they have any recommendations of how to fix it. So they did write a letter back to the chair, and then we had the testimony from several stakeholders saying that this bill is needed, and there was also some opposing testimony from some stakeholders, and here we are.
Ms. Marshall, do you wish to speak?
Yes, thank you, Mr. Chairman. Members of the subcommittee, I accepted the chair's invitation to appear today, primarily because I wanted to correct the record and dispel any potential misconceptions the subcommittee may have as a result of Delegate Carr's incorrect and derogatory statements about the Compliance Board in last week's hearing. I'd like to give you the timeline of events so that you have an accurate picture. As you know, Delegate Carr is sponsoring 2 bills affecting the Open Meetings Act, one of which he also brought forward in last year's session. In last week's hearing, Delegate Carr told you that the Compliance Board was not willing to meet with him to discuss his bills, nor to appear last week. In fact, the Compliance Board has reached out to Delegate Carr over the past year on both bills, and the board discussed his bills in 3 public meetings that he was welcome to attend. As I'm sure you know, there are only 2 ways that the Compliance Board, a public body, could have discussions with Delegate Carr about a bill and comply with the Open Meetings Act are 1, to discuss the matter in open public meetings, and secondly, for one board member to discuss the bill with the delegate, then relay that discussion to the board in an open meeting. We offered both of those options to Delegate Carr for both of his bills. As I indicated, in total, the Compliance Board has discussed and prepared written input on Delegate Carr's bills through 3 open meetings, all of which were audio conferences that are posted on the Compliance Board's webpage online. The first public discussion was in our meeting on January 28th of last year. The Compliance Board had only recently received Delegate Carr's bill, so we briefly discussed it and scheduled a follow-up meeting on the bill for February 4th. In the interim, one of our board members reached out to Delegate Carr's office to attempt to discuss the bill with him and received no response. Then in our February 4th audio conference meeting, I specifically asked if Delegate Carr was on the call and wanted to speak with us. That is at approximately 3:30, and the audio recording of that meeting on the Compliance Board's webpage. Delegate Carr did not call into the meeting. After the board discussed the bill in that meeting, we submitted our written comments to the subcommittee. We opposed the bill because the proposed amendment would almost certainly place additional burdens on our small volunteer board and most certainly on public bodies with no appreciable public benefit in our view. Months later, in late July, I received a letter from Chair Pendergrass asking the board to conduct a study on the issues raised by the bill and to include Delegate Carr in our discussions. I had a phone call with the chair and some subcommittee staffers in early August, in which I explained why the board would not be accepting their invitation to conduct a study. I told the chair that the board had already attempted to discuss the matter with Delegate Carr before deliberating in open meetings and taking our position on the bill. Importantly, and contrary to Delegate Carr's assertion in last week's hearing, nothing in the Open Meetings Act requires the Compliance Board to work with individual legislators on proposed bills, nor to conduct studies at the request of individual legislators. Section 3204C of the Act requires the Compliance Board to study ongoing compliance issues and make recommendations for improvements to the General Assembly. An example of that would be if in the course of resolving complaints, the board found that many public bodies were misconstruing a particular provision of the Act. The only study I'm aware of the Compliance Board ever conducting was in 2005, and that study involved what is now the administrative function exclusion to the Open Meetings Act, which is also the subject of Delegate Carr's bill. The Compliance Board at that time recommended no changes to the exclusion other than renaming it from the prior name executive function exclusion. When I mentioned the 2005 study to Chair Pendergrass and the staffers on our August call, they asked me to provide the study and the other information regarding the board's work on Delegate Carr's bill that I'm relaying to you today. I agreed and told the chair that the board would discuss the matter in our upcoming annual meeting on August 29th of 2021. Delegate Carr did not attend that meeting. Our discussion on the matter begins at about 8.5 minutes into the audio recorded meeting on the Open Meetings Compliance Board webpage if members would like to listen to it. The board's additional written input, including the 2005 study, some relevant citations to board opinions, and some relevant complaint statistics were provided to the subcommittee shortly after that August 29th meeting. I didn't hear anything more on the matter after that, so presumably the additional information satisfied the subcommittee's needs from the board, as I had been told would be the case on our August call. More recently, in early November, Delegate Carr sent the board a draft of what is now House Bill 246, his second proposed amendment to the Open Meetings Act that you've just discussed, and asked for the board's feedback. In mid-November, the board's counsel relayed by email to Delegate Carr my offer to speak with him one-on-one or for him to attend the open meeting we were convening on December 9th to discuss his second bill. Delegate Carr replied that he had no additional information for us yet, and he did not attend our meeting. The board discussed his bill and then provided written input to Delegate Carr and the subcommittee. On January 13th, a couple of weeks ago, Delegate Carr emailed our board's counsel saying that a date for the virtual subcommittee hearing on his bills had not been set, but that he encouraged someone from the board to attend and engage in a dialogue with the subcommittee. The Compliance Board never received an invitation from the delegate with a hearing date, as I received for today's hearing from the chair's office. The Attorney General's office happened to notice 2 days before last week's hearing that that Open Meetings Act legislation was included, so we hurried to resubmit all of our materials to the subcommittee on both bills as written testimony. In summary, the Compliance Board gave considerable and fully transparent attention to Delegate Carr's proposed bills, and we gave him a total of 5 opportunities to engage in a dialogue with us. As I've indicated, the administrative function exclusion to the Act, including the fact that personnel discussions can fall within that exclusion, was studied by the board in 2005, and no changes to the exclusion were recommended. Since that time, nothing more has occurred that would necessitate Delegate Carr's proposed amendment to the Act in our view. As I told Delegate Pendergrass last August, and as Delegate Carr himself mentioned in last week's hearing, the stimulus for his bill was apparently one experience that he had with one public body, and he made a complaint to the Compliance Board about that matter. That one experience is not a sufficient reason, in our view, to subject all public bodies in the state, as well as our small volunteer board, to the additional burdens of his proposed amendment to the Act. As we've said in our open meetings and written testimony, if personnel matters were subject to the Act, that would usually necessitate their discussion in closed sessions. To further explain, here is a list of the numerous things a public body must do in order to meet in closed session. Provide notice of the meeting, make an agenda available, designate at least one member to be trained on the Act, convene an open session, making sure that at least one member present has been designated to be trained on the Act or complete and retain the Office of Attorney General's compliance checklist. Have the presiding officer prepare a written closing statement disclosing the reason for closing the meeting, citing the authority for closure and listing the topics to be discussed. Conduct a recorded vote on closing the meeting. Allow the public to object to closure. Prepare and retain minutes, which will remain sealed and confidential, and prepare a closed session summary to appear in the minutes of the public body's next open session. The summary must include a statement of the time, place, and purpose of the closed session, a record of the vote of each member as to closing the session, a citation of the authority to close, and a listing of the topics of discussion, persons present, and each action taken during the session. However, and importantly, the summary need not reveal confidential information from the meeting. So for example, if an employee's performance were discussed, not even the employee's name need appear in the summary, much less what was discussed. So as to whether Delegate Carr's proposed amendment would increase transparency, a public body would have to disclose to the public that it had discussed and potentially taken action on a personnel matter. So that, along with the other requirements for closed sessions, would create a paper trail of sorts, but the paper trail would be very limited. The public wouldn't necessarily know what employee was involved, nor what the public body said about that employee behind closed doors. On the other hand, each one of the many statutory requirements I've just described for closing meetings might be a basis for complaints to the Compliance Board about each individual personnel matter, no matter how small, discussed in a closed meeting. Ultimately then, in the Compliance Board's view, and as we've stated in our written testimony, no appreciable additional public transparency would result from this bill that would warrant the likely additional burdens on our small volunteer Compliance Board and on public bodies in the state. And I thank you for hearing from me.
There are two members with raised hands, three. We will proceed with them and anyone else. Delegate Kaiser, followed by Delegate Young.
Mr. Chairman, thank you. I don't really have a question, but Ms. Marshall, I appreciate the long explanation that you just read to us, and clearly you're noting your disagreement with Delegate Carr. But having known him for over 10 years, I would suggest that he has never done anything derogatory in his life. And I think your statement in that way was, in fact, derogatory. Thank you, Mr. Chairman.
Thank you, Delegate. Delegate Young, followed by Delegate Kipke.
Thank you, Mr. Chair. First of all, let me voice my concurrence with Delegate Kaiser's statement. Secondly, I'd like to ask Ms. Marshall whether the Open Meetings Compliance Board has had a full contingency of 3 members.
Delegate, I've been on the Compliance Board for about 1.5 years. During that time, there's only been a brief time that we've had a full contingency of 3 members. We currently have 1 vacancy. We've had 1 vacancy most of the time that I've been on the board. So we barely have a quorum with the 2 members that are currently on the board.
So how long have you only had 2 members?
I believe that our most recent 3rd member had to leave the board early last summer. That's off the top of my head.
is there a corrective action plan for the lack of a full board?
Well, Delegate, with two members of the board constituting a quorum, we've continued our work with myself and my colleague, the two members that we have on the board. I'm not aware of any particular input that we've been requested to give or that we have given with respect to the vacancy. That's up to my understanding is that's up to the government's appointments office on timing and appointing a third member.
Thank you.
Delegate Kipke.
Thank you, Mr. Chairman. I'm just going to suggest that with the lack of collaboration and the fact that there's still opposition to the bill, that this bill be tabled for some point in the future so that there can be a little bit more work done on it. I don't know if Delegate Carr wants the opportunity to respond or not. That's up to him. But, recalling how this bill went last year and seeing that not much has changed, and with the testimony given by Ms. Marshall today, it seems like it might need a little bit more work. So I'm just going to throw that out there. I'm not making a motion. I defer to the chairman, but just my thoughts on the matter. Thank you.
Delegate Carr, do you wish to speak?
Yeah, thank you, Mr. Chairman. So yeah, I leave it to the wisdom of this subcommittee, what you want to do with the bill. I do feel strongly that the bill is needed. I do not think it will be a burden on public bodies or the Open Meetings Compliance Board. While I did have, an incident that sort of triggered my research and my thinking of the need for the bill, that wasn't the only thing that influenced my thought process on the need for the bill. The bill was actually suggested by another individual, Mr. Craig O'Donnell, who testified at the hearing, who has sort of become an expert from a requester's standpoint. So I think taking the requester's point of view, this is a bill that is needed. These types of meetings, there would be no record of them because they fall under the administrative function. The public would never know whether they existed. And by passing this bill, there would at least be a paper trail of and some accountability that the meeting did occur. When did it occur? Where did it occur? That's a best practice. It's clearly identified in the Open Meetings Manual of what bodies should do to avoid that gray area. Most public bodies do follow that practice, but some don't. And this is a way of sort of closing off that that practice that is less than optimal. But again, totally respect whatever decision the subcommittee wants to make on the bill.
Delegate Kipke.
I think that might be an opportunity for Ms. Marshall to respond to. The delegate reasserted why the bill is necessary. My summary of what you've said is that it requires more work with no public gain. But could you respond directly to what the delegate just said as he continues to advocate for the bill? Thank you.
Delegate, as we've stated in our written testimony, and as I've stated here today, the Compliance Board's view is that the bill is not necessary as it does not appreciably increase transparency that would outweigh the additional burdens on public bodies and on our small volunteer compliance board. That's our position, our carefully considered position through several open meetings in which we deliberated. We disagree with his assessment on the need for this bill based on our experience in resolving complaints, and that's our position. That's what I have to say.
I have a substantive question. What does direct jurisdiction mean? Would that mean that any employee of the agency or the would be, the public body would be covered so that any such discussion of any employee, is that what direct jurisdiction means?
No,
Right.
that was a change, I believe, made last year to specifically tailor the bill so that it wouldn't cover all of the employees. I'm struggling now to come up with an example, but if you had a public body that had like an executive director, generally speaking, the public body would be responsible for that executive director, but then the hiring, firing, promotion of the rest of the staff would be delegated from the public body to that executive director. So this would then just apply to the executive director of that public body, not all of the rest of the employees that the executive director is responsible for.
But I'm going to accept the wise counsel of our colleague from Anne Arundel County and hold this bill and see what may transpire between now and next week's meeting of the subcommittee. So with thanks to all members of the subcommittee, because I think we worked across party lines and achieved some positive results today. And hope that is a good omen for the remaining 70 days. So we are adjourned. The full committee meets at 1:30, correct? Is that correct, Council? Full committee is at 1:30 or 1 o'clock?
Yes, 1:30. There's no briefing today, I don't believe so.
No, there's a briefing at 4 o'clock.
I mean, I'm sorry. Generally speaking, if the briefing were going to happen before bill hearings, it would have been at 1.
That's fine. Since I'm the maestro of the briefings, I'm aware, for this time at least. We will see. Thank you all very much. We will see you at 1:30. Thank you. We are adjourned.